as well as the private respondent participated. Stop. In the said selection process also, 7 questions were found to be incorrect. Stop. The authority proceeded with 93 questions out of 100. Stop. The petitioner challenged the same before the tribunal on the ground that the rules of the game cannot be changed once the game started or in the midst of the game. Cannot be changed in the midst of the game. Stop. Paragraph. The tribunal initially passed an interim order
At page 296.
directing that the selection process pertaining to the examination will be kept in abeyance. Stop. Thereafter, an application was filed by the private respondent and also by the administration, highlighting that because of scarcity of labor inspectors, the administration will find it difficult to proceed with the day-to-day affairs. So, the application for vacating the interim order was considered by the tribunal, and after hearing submission made on behalf of all the parties, the tribunal was of the opinion that on evaluation of the balance of convenience, it is expedient in the interest of justice to proceed with the selection process. Stop. The tribunal clearly recorded that the final selection shall be done only after getting leave of the tribunal. Stop. Paragraph. According to the petitioner, since the reason for vacating the interim order was already in existence on the day the interim order was passed, the interim order ought not to have been vacated. Stop. It has been submitted that there has been no change in circumstances for vacating the interim order. Paragraph. We have heard the submissions made on behalf of both the parties, of all the parties, not both. And on perusal of the documents placed before the court, it appears that the right of the petitioner has been well protected by the tribunal. Stop. The tribunal has mentioned that the final selection shall be done only after getting leave of the tribunal. Stop. The tribunal has rightly recorded that the original applicant will not derive any corresponding benefit by keeping the proceeding in abeyance indefinitely. Stop. Next. The earlier selection process in which the petitioner participated stood scrapped by the administration. Stop. Paragraph. As of now, it does not appear that the petitioner can be aggrieved by any manner because of the vacating the interim order. Stop. Next. It will be open for the petitioner to raise all points before the tribunal at the time of final hearing. The writ application stands disposed of.
Okay.
Madam, please take back this judgment.
Item number 2, the PFT that's in report. Copy that.
This is, my lord, basically a public interest litigation, my lord. involving
Consumer forum.
only no, my lord. Involving two issues, my lord. That's non-supply of uninterrupted electricity supply to the people, my lord. We are facing a disruption of about 5 to 6 hours of electricity per day, my lord. And secondly, my lord, the central government has notified a rules for payment of compensation, my lord, on account of disruption. My lords would hear it whenever the affidavits are complete. After hearing parties, my lord, the administration and the central government both were directed to file a report, my lord. As far as the administration, my lord, is concerned, they have filed a report, my lord. The central government was supposed to file a report on a particular project, my lord. The administration, my lord, has recommended for installing and commissioning of a 50 megawatt LNG project, my lord. That's liquefied nitrogen gas project, my lord, which possibly would address the electricity shortage in Port Blair, my lord. The administration has been constantly pursuing the matter with the central government, my lord. And the central government has been keeping it in abeyance and dragging the issue, my lord. So the central government was supposed to file a specific report on the aforesaid issue as to what is the status of the central government on approving the 50 megawatt LNG project.
Where is that report?
I need to do the last problem.
All right.
There was a petitioner was asked to supply a copy of the resolution.
I keep supplying throughout the year.
It's not. There's a
Ask
direction to
your clients.
there's a direction to supply the copy to me.
You could have asked me, sir.
I have asked you.
You have asked me. Your client was sent, and as per my information, the local administration had also forwarded a copy to the central government. This is not the way by my learned friend to drag the matter.
It is not.
It's a common phenomena.
The order speaks that he will be supplying a copy to me. He has not
Listen,
said-
this should not have been the manner in which it is to be proceeded. This is a public interest litigation. It is involving all public.
I was not aware of the fact that the copy was served on the.
Why did you contact with your client?
Yes, I know. We're- Unless until a copy is given, we are going to write.
There is an order, your presence is recorded.
Why not I have,
The,
in my absence, this order was passed, the direction was given to the.
how did you get to know it today?
It was letter communicated to me, I have.
When it was communicated to you,
Downloaded the copy from the website.
and then you could not request for a copy
Why not?
in the event.
Send a copy, why not? I have.
Is,
It will be given later on.
This practice from a senior member of the bar.
this is
What
what,
I'm saying, characters and I have been, I asked me the supply a copy to me.
imagine, see how matters are being dragged.
He said the islanders are suffering, students are suffering, their education is being hampered. And has to be, take the matters,
I would have taken a certified copy. He was-
nobody individually is going to benefit out of this matter.
Please inquire from your clients whether your clients have received a copy or not. In the event, you can take a copy and make a photocopy on yourself, at your own cost, because this is a public interest litigation.
I will copy.
He'll make a photocopy at his own
I
cost.
do it, my lord.
I will.
I have only one
This
copy.
is-
I don't get my copy back, then I'll be without a copy.
I will request the state. to
Please
give the
come.
copy to me.
The submission, the state has already given a copy.
I don't want to.
Forward a soft copy.
I don't want to put much into detail. The joint secretary of the ministry called me personally and requested for a hard copy of the writ application, which was forwarded by mail to him about 15 days back. This is not appreciated.
Mail is given
This is
to
not
me,
appreciated.
supply it to, by mail to me.
Forward a soft copy. Do not, you are not required to forward the hard copy once again. Forward a soft copy.
My lord, actually, during the course of.
Report by the Secretary within bracket power, Andaman and Nicobar Administration. Dated 9th of December 2024. Filed in court today is taken on record. What does your report say?
My lord, I have just now, I also actually
You
don't have a
know,
copy.
Has copy been served up?
Yes, just today, just now, 10 minutes. back.
Well,
Okay. We are
The-
obviously,
It has to be
Report.
heard out only once the union comes.
Right, the report by the union is yet to be prepared. Stop. Let the same be prepared and circulated positively by 27th of December 2024. Stop. Let the matter appear in the first day of the second week in the next circuit.
Obliged.
The authorities shall keep in mind that the Writ petition is a public interest litigation involving the welfare of the public at large, and the authorities ought not to drag the issue unnecessarily.
Obliged.
Item number 3, CRS 6 of 2024.
Appellant, thus affidavit of service has not been affected. Let it be posted the day after tomorrow, my lord.
Has it been served?
Not sub,
Not
not
served.
sub.
Copy of the appeal is yet to be served. Stuff. Let the matter appear in the next circuit. Service in the meantime.
Obliged, my lord.
Item number 4, payment is 65 of 2024.
Yes, my lords. Lords, copy was served upon the counsel for the respondent. My lords, the matter pertains to
Full responded in
Respondent.
sole respondent. My lords, this appeal, my lords, is challenging the order of the learned single judge, wherein it was held that the tribunal constituted under the Senior Citizens Act does not have the powers to evict a tenant. That is the
In the appeal,
any
you have not made the state as a party.
Yes.
The official
Yes.
respondents.
my lords, this
Without the official respondents, how can the matter be heard?
was the official response. It would be the deputy commissioner's office. And
It is.
And the interim order was passed by the deputy commissioner's office and was supported. There are a few party, my lords. I'll make the amendments and I'll add them as a party. But the essential dispute, my lords, is with the respondent.
Formal amendment. The writ petition was filed
Any words?
against the official respondent.
Any words?
The appeal, all the parties who were there before the trial court are required to be implemented as parties. You cannot just drop them. Any of them.
I'll add them as a party. my lord.
You are required to add.
May I carry out an amendment, your lordship? With your lordship's kind permission, I will add the deputy commissioner's office as a respondent number 2. The sum and substance, your lordship, if lordship,
Questions will go later on. First, let the technical issue
your lordship,
corrected.
operation lords.
Is not detected. How come, who has prepared this report? The stamp reporter? How can it be that the defect was not detected? The administration is not a party in the appeal and it was not detected? Take down. The appeal is defective. Stuff. The official respondents who were parties, how many were there? 1 or 2?
2, your lordship.
Official respondents
Page.
who were parties in the writ petition have not been impleaded. No, there is only one, the deputy commissioner.
Only the deputy commissioner.
One.
Page 37.
Private respondents. Here. Yes. Private respondent has not been impleaded as party respondent in the appeal. Stop. Paragraph. Leave is granted to the advocate on record of the appellants to make necessary amendment. Stop. List day after tomorrow,
Operation lords.
because you are required to serve also. In that case, on Thursday.
Thursday.
List on Thursday.
Thursday, gratefully, lord.
all the stamp reporter ones in the chamber.
Number 5. Committee 69 of 124.
As directed, my lord, report has been filed.
I have some difficulty today because today morning only the copy has been.
I'll not rely upon that second
Oh,
supplementary.
You,
I'm the director.
alright.
She is the private respondent, my lord, at her instance. My lord, if my lords would remember that at her instance, the London single judge, my lord, directed demolition of my building. There are twofold issues, my lord, before entering into the merits of the matter, my lord. Number one, my lord, when the writ petition was moved, admittedly, I was not served with a notice, my lord. I was not heard. The order of demolition, my lord, was passed without hearing me, my lord, at the motion stage, my lord. Second, my lord, even on that particular day, the statutory appeal, the second statutory appeal was filed and it was pending before the Lieutenant Governor, my lord. The said fact was not brought to the notice of the learned single judge. Possibly then this order of demolition would not have been passed, my lord. My lord, if there are a lot of issues and merits, I can
Is
address.
anything left to be demolished or everything has been
No,
demolished?
they have removed the structures, my lord, the roof, my lord, and the tubular structures, my lord. And they have vacated the tenants, my lord, of the one of the floors. The actual demolition, possibly by today, they would start, my lord.
Alright.
My lord,
Where is the report of the council?
Submitted.
Yes,
my lord,
That
the
Well,
private respondent is the landlord.
page 5.
my lord, there is a dispute, my lord, between the private respondent and the appellants, my lord. Their relatives, my lord.
Relatives.
There was a gift, my lord, executed in my favor and the other co-shareholders, my lord, which has been challenged by Mrs. Nag in a civil suit, my lord. She claims, my lord, she is entitled to 1/5 of the share. Assuming for the purpose of argument that I fail in the suit, my lord, she would get only 300 odd square meters of the land. This is 1,349 square meters of the land. The subject land, but the construction has been undertaken, would not get affected irrespective of the outcome of the suit, my lord, because there's substantial area therein, my lord. The suit, my lord, was decreed in favor of Mrs. Nag's client, my lord, where the gift was set aside, my lord. Certain issues were not brought to the notice of the court below. I'm not going much into it because the suit is it is before the first appellate authority, my lord. It's on a remand, my lord. It's not a remand de novo, so therefore the first it is only for the limited purpose of hearing the appeal afresh. So therefore the order of injunction which was passed by the first appellate authority would definitely survive, my lord. This is the part as far as the question of my entitlement with respect to the land is concerned, my lord. Well, as far as the merits is concerned, my lord, during the year 2000, I had submitted a building plan, my lord, before the municipal authorities on 31st of January 2020, my lord. There are two issues, my lord, substantial issues which are involved. This I would be indicating, my lord, but I would request, my lords, not to go into the merit because, my lord, if those factors are gone into merit, the parties, my lord, particularly myself, would be losing two forums, particularly the appeal which is pending before the Lieutenant Governor, or as also with, my lord, the single bench, my lord, because these issues have not been addressed. I make an application, my lord, for sanction of my building plan on 31st of January 2020, my lord. Very interesting, my lord. Mrs. Nag's client move a writ application before the learned single judge, my lord, which is disposed of on 2nd of March 2020. My lord, may kindly come. I filed a second supplementary affidavit, my lord, today.
Where is the second supplementary?
देखो क्या है वहां से लाया नहीं लाया.
What does the report?
He said he won't rely upon.
I'm relying upon a judgment. I am only relying upon a judgment of this honorable court, which was passed at the instance of Mrs. Nag's client, my lord. Well, there was a judgment of this honorable court, my lord, in 2020 on 2nd of March 2020, my lord. She makes a complaint against me. The learned single judge, my lord, passes an order directing the municipal authorities to address into the complaint made by Mrs. Nag's client and also directs the municipal authorities to take into account and dispose of my pending application for approval of the building plan, my
Did
lord.
you go through the report filed by the
I have,
council? So what does it say?
they don't say, my lord, anything. They have only enclosed all the documents which I already have, my
Page
lord.
5 may be seen, my lord.
So what is the position?
We
The
have
sanction plan?
Yes, each stage, my lord, notice has been given to the parties. There is no.
No.
Kindly
Both
see
the
page five.
parties?
Yes,
Yes.
my lord, kindly see.
What
page
about
five.
the second appeal which is being submitted to remain pending?
That second appeal is pending, my lord.
Still pending?
Pending, my lord.
Yes, before the lieutenant governor.
If that remains pending and the structure is demolished, then the appeal itself
There
becomes
is no, then they
infructuous.
have to get us, they
Pray
can
for a
apply for a
stay.
I
stay
would-
before the second appeal.
Find an application for stay, if the stay is not getting disposed of, then I.
Im-
See, application is not a friendly one. What is this, you know?
But would the learned single judge would not have passed the order, my lord, on the aforesaid day if I was heard. Why the writ petitioner did not serve me?
You, we'll give you permission, you go and prefer
Take 10 days, 2 weeks of time, I'll move an application for stay, my lord.
2 weeks.
1 week, 10 days, some breathing time, my lord.
You-
He has the High Court is functioning, my lord, the tribunal is also.
One submission, very important submission. His second appeal in no circumstances will be dismissed. The reason is that he is not the owner of the property now.
You raise all points.
All
before the
points.
Second appellate
My
authority.
plan is under the doing, under.
I do not get a plan.
Sanction.
I get it.
Worship, I pray that no agree want to be granted.
I am the owner of the property. The mutation is, the land is in my name as of today. There is an order of stay of the London District Judge by the First Appellate Court.
Moreover, your worship, before the single
The,
judge, the municipal council.
petitioner is aggrieved by the order of demolition. Stop. A second appeal in connection with the said impugned order is pending consideration at the end of the Lieutenant Governor. Stop. Next. The learned advocate representing the private respondent submits that the petitioner is not the petitioner, the appellant. The appellant is not the owner of the subject land, and accordingly, question of grant of
Which I am disputing,
Sanction.
my lord.
cannot arise at all. Stop. The aforesaid submission is disputed by the learned advocate representing the appellant. Paragraph. Be that as it may, as it appears that the second appeal is pending consideration before the Lieutenant Governor, comma, accordingly, it will be open for the appellant to approach the second appellate authority with his prayer for stay. Stop. In the event such an application is made within a week from date, comma, the same shall be considered by the authority in accordance with law after giving opportunity, giving a reasonable opportunity of hearing to all the necessary parties.
Worship, when the appeal was been filed, that also will be looked into 3-4 days before. 5th December. was
It
filed.
will be open for all the parties to raise all issues before the Lieutenant Governor at the time of consideration of the prayer of the appellant. The appeal stands disposed of.
Well, the order of the learned single judge, man.
Which page do we get that?
Well,
Memo. Where is that order? 13 November 2024.
13 November, man. Yes, it has to be.
The impugned order dated 13 November 2024 shall be kept in abeyance till the matter is disposed of by the second appellate authority.
Blanket ordinance.
Obliged, ma'am.
For last one more than 1 year.
The Lieutenant Governor is requested to dispose of the prayer of the parties at the earliest, but positively within a period of 3 months from the date of communication. If it is one, I do not know how soon it functions.
No, 1 month. No, my lord, large pendency, my lord. Let it be.
Why should things remain pending?
Because
for-
there are several, Lieutenant Governor has other, my lord, administrative duties also, my lord. So, my lord,
3 months.
3 months is fine.
My lord, that time limit for preparing an stay, my lord, instead of 1 week, at least 2 weeks, my lord.
Why?
My lord, the tribunal is also functioning from today, my lord.
So you won't function.
The appeal
To-
is barred by limitation.
Section 5 has been, it has been filed,
Make it 10 days.
my lord. Oblige.
All connected applications disposed of.
Judgments. इसका पैरा नंबर में बोला था तो इसमें कहीं लिखा होता
Item number 6.
This matter, my lord, I have examined the legal position. My lord, the facts are like this, my lord, that
This is my appeal. Let me take
my
this.
appeal. My appeal. Up to 17th order challenge किया आपका appeal.
I do not find it is
This is
your
my
appeal.
appeal, my lord. ये आज नहीं है, वो कल है.
All right. Oh, I'm so sorry.
That is tomorrow, my lord. That is coming tomorrow.
Yes, sir. This is
My lord, here, my lord, this award was challenged by.
copy भी given.
No, copy was served. I have service. I have affected service here. My lord, what I am on, my lord, here pleadings were completed before the trial court. This require informal paper.
All right. No interim order.
No, no entry.
What is the order of challenge?
Labor court has passed an award whereby directed reinstatement with back wages.
All right.
First appellate, the writ court, without considering the evidence on record, rather their part of the writ petition, the documents which were there, passed an order saying that they have not worked for 240 days. Rather, before the trial court and in the writ petition, those documents whereby they admitted that I worked for 290 days. That was overlooked by the writ court, and writ court arrived to a finding that the evidence which was given by the respondent, that is the administration, the authority, was the officer who was doubtful how he has given that, because he has given that on the basis of the document which was placed before him for the trial court in cross examination. He admitted, yes, this is the document whereby they have worked for 240 days.
Detailed and well considered judgment.
Yes,
I see page 20 pages judgment.
Yes.
Obviously. Please come.
What is
The appeal is required to be,
affidavit of
Third.
service?
let paper books be prepared and exchanged by 30th of
No,
December,
no, my lord. 4 week time may be given.
4 weeks
4 weeks. So next circuit.
by the next circuit. By the first day of the next circuit? First day of the next circuit?
My lord. Or liberty may be given to mention, my lord, the paper book once prepared.
Director to file paper,
कब आएगा?
do one thing, to file paper
नहीं
books.
दिया है आपके डिपार्टमेंट को सर्विस.
Liberty to mention the matter after paper book is made ready and served upon the respondent authority.
My lord, 6 and 7 arising out of same judgment, my lord.
All right, same order.
And 8 also, my lord, after full dressed hearing, my lord. We have lengthy hearing, the matter was, my writ was dismissed.
Separate matter.
Separate matter.
But then same order.
Same order,
direction
same order,
Preparing
same order,
paper
same
books.
order.
All right, same. So only one line order, file paper book, liberty to mention.
My lord. Oblige.
I'm prepared.
Item 9, 9/16/2020.
Lordship, in this matter, I am for the appeal, and your lordship, a short question is to be decided by the Summary Court. In this paper,
State, my lord, main is.
state, no, not at all. State is the main authority, your lordship.
If there are private parties, they
First one, yes,
we,
private part, yes, your lordship.
where are they?
My
Your lordship, I am praying for next circuit, your lordship.
a short question of involve your lordship. Whether
Maybe seen it. will be-
your lordship, no, your lordship. Your lordship was pleased to allow me.
Friend seeks time.
Kindly appreciate your lordship. Your lordship was pleased to ask me to have the substitution, your lordship, on considering that point, your lordship. Your lordship order was there, your lordship, to substitute. It's a dispute between your lordship, father and daughter, your lordship. The two sisters, your lordship, they are there. One is the petitioner and other is the private respondent, your lordship. During the lifetime of the father, your lordship, in the same building, we all were used to live, your lordship, but the father was living with the elder sister. So the father, your lordship, moved an application under the Senior Citizen Welfare Act, and got the order of eviction, your lordship. Thereafter, I challenged the order before this writ court, your lordship, and writ court upheld the order passed by the your lordship, senior tribunal, lordship. During the pendency of the appeal, thereafter file appeal. During the pendency of the appeal, your lordship, my father expired. Thereafter, the matter came before your lordship, and I placed certain point, your lordship, because in the impugn order, your lordship, there is a observation made by the tribunal, trial court, your lordship, that the P78 land which has been regularized and given to the party concerned is for the benefit of the family. This has to be decided by this honorable court, but the trial court has said that no, it is not for the benefit of the family, and some doubt has been raised whether the same has been granted under the regulation scheme or not, your lordship. So, your lordship, please to allow me to substitute the legal on this point, your lordship, and I'll.
Then this is to be heard and there is a request for posting the matter in the next circuit. Next circuit, letter come.
Lordship, lordship.
Paper book is already filed.
File.
Paper book has been filed. Stop. On the prayer of the learned advocate representing the private respondent. Hearing of the matter stands adjourned till the next circuit.
Lordship, deeply your lordship.
Lordship, I for the appellant, state lordship. So appeal against acquittal.
Wait.
Respondent number 5, 6, and 7.
You are appearing?
Yes. My senior Mr. Govind.
All respondents are appearing. Yes, start lordship.
Yes.
Alright. The respondents were acquitted from the charge under POXO Act, lordship. The state has preferred this appeal, lordship. Before the trial court, lordship, total 15 witnesses were examined by the prosecution, lordship. There are
Any mentioning not in the list? Any mentioning in the list? Item not 30. Out of my list.
1 minute, yes.
Out of the list.
Out of the list. Yes.
Already direction is. Only responded to file application now that I have informed the other side. They are available. So let it be come tomorrow.
Let it appear.
My lord, my children, Mrs. Nad is appearing on behalf of the opposite party. I'm mentioning one matter. My lord. Last week also we have mentioned this matter, but the matter has not been listed, my lord. So in the last week also, the honorable court has ordered that the file may be come from Calcutta to this circuit. File has come, but this matter has not listed, my lord. So there is an urgency.
All right, all right. What is in over? Okay, it will be listed.
Item not 30.
Yes.
I'm not feeling well. Let nothing taken up.
Item 30, arbitration. Very well.
My name.
All right.
Yes, ma'am. Item number on.
The worship I for the petitioner, the worship I mention this matter. There has been a direction to file everything opposition by the other side. The worship opposition has not been filed, but the other side is carrying out the construction over the pathway despite the order of stay granted by the center. This is the position.
Who is for the answering respondent? Answering respondent? Or you are making construction?
What they allege, what they allege.
Yes.
I'm for the.
Report is there, the report is there, they are carrying out construction.
Time already.
1 minute. Is the opposition on record?
No, but the private respondent has not filed the order.
Time is not that.
No,
Clarification issue on Wednesday, this matter can be taken to final. I use my reply.
You have filed. What is your stand? Is unauthorized construction is there and it's been. What steps are you taking to stop it? Is there any stay order?
no stay order against the petitioners,
Both the parties.
both the parties, not to the government, specifically mentioned.
1 minute. Where is the stay?
Yes.
This present application disposed of directing the petitioners and respond number 3 restraining them from carrying out any kind of constructional works.
But there
If-
has not been any restraint upon the authorities, but the authorities are doing nothing. They should evict him. But
Let
on the
me,
pathway.
let this matter be taken up on Wednesday for final hearing.
Yes, it will be taken up. It has been submitted by the learned advocate representing the petitioners that despite an order of injunction being passed, no, despite an order has been passed by the court on 4th October 2024, restraining the parties from carrying out any kind of constructional activity, comma, the private respondent is merely continuing with the construction work, defying the court's order. Paragraph. Learned advocate representing the official respondents submits that unauthorized construction has been detected. Paragraph. What steps is the authority taking to deal with the unauthorized construction? Where is that? In the opposition.
We have already passed the eviction order, but they're not implementing it.
Page 7, yes. Report regarding encroachment.
Last part. Board has been occupied.
Occupied by the respondent, planted some coconut trees and some of the area used for gardening over the said common revenue law.
This is your finding that there is an encroachment and there is violation of the court's order. But what is the remedial steps that you have taken? And so you are keeping quiet. What is your writ petition for implementing the order?
Implementing the eviction order.
Right, I get it.
My case is, in view of the local regulation, if I file a suit, because my land, my recorded property is by the side. I am carrying out work in my recorded property. So these things were considered by the court by granting interim protection. They say the path has to be laid in between my land. That's the whole dispute.
Was any physical inspection
Nothing,
conducted?
nothing was done, nothing was done, nothing was done.
The,
It was done, Your Lordship. After physical inspection, this report, after, yes, everything, and. Your
And
Lordship,
was
there's no
the-
civil suit pending.
Civil suit
Incorrect
pending.
submission is
Yes,
made.
it's there
I
already
will
on
show
record.
it.
was the inspection conducted upon notice to the parties?
For passing the eviction order.
No, not, this is, it was never done. The authorities are in connection with
All
the
the
petition.
records are
Page
there.
7 says that as per the field inspection report.
So that the notice has been served to me. Simply dispatching will not do lot. For the record, they maintain notices prepared.
He knows
But let them
everything.
show that it has been duly served to me. I acknowledge the notice, then I'm acting
Moreover, that
in
is, this
deference
is
to the
not
order.
his writ petition. He has not challenged the eviction order. in-
Please,
It's a matter of to be gone into the main bit.
in the main writ only implementation will be done. Your stand cannot be taken into consideration.
Cannot be done. That's the point to be decided by this court in the main bit. Can that be done or not?
There or not.
Tendency of the suit, because under the local regulation, it's permissible. It's a fact of filing a.
The suit can remain pending for years together. Does it mean, does it
I am
mean?
submitting, Your Lordship, I am submitting, no civil suit is
It's
pending.
there,
I
my
am
lord.
submitting.
Show me.
Let him show,
It's the part of the opposition which
Yes,
are filed
let
and
him
then
show.
the interim application.
and let him show the, let him show that.
Where, part of the opposition, देखो तो कौन सा?
As against the interim application,
Page.
not kindly see,
Page,
page 7.
page 7. Yes, in the court of the civil judge. Where are the orders?
Just show the order one is there sought for implementation. I'll just show that in the plain.
Plain ministers.
Not yes, yes.
Yes.
Not paragraph 10 may kindly be seen. 9 July 2024 order of the Tahsildar Prajanj.
Paragraph 9 of your suit.
10, page 10, paragraph 10.
Page 10, paragraph out of authority, pro forma issued eviction notice, but very interesting copy of such was not addressed to the plaintiff, rather it's given to the defendant.
Where may be seen, Your Lordship? Decree, there should be a frame for that. For setting aside or quashing of that particular order of this. Nothing is there. Now kindly come to the schedule of property. Kindly come to that.
And not this is
So
an
let
eviction order.
let us see one by one. Let us see the schedule of property. Page number 13.
Yes,
Kindly see government revenue land survey number 1/3. Here the survey number is 1/20. Totally different. How he can say that civil suit is pending?
But kindly see the eviction order.
Yes.
It just seeks to implement.
no, but then maybe eviction order in respect of 1/3 is also there.
No, that means yes.
He himself is imagining.
No, it's not my imagination. I cannot imagine. And nobody
This
imagine.
survey-
It's based on record.
The survey number over here is 1/20.
But
You are relying upon a title suit in respect
kindly
of,
see the eviction order, which just seeks for implementation. It comprises these two survey numbers.
Both?
Yes,
No,
I'll show that.
no, yes.
Yes, no will not do. I'm saying based on documents.
Clearly seen here. 1/3 is
I'll
not
just show.
shown there.
The writ petition may kindly be taken up along.
Page 49. 49 eviction order. Where is 1/3? I don't understand.
1/20 is found,
Just
page
one second,
7.
Just one.
I am concerned with 1/20 only. I am not concerned with other 1/3.
Hence, he is bearing
The
survey
order
number
is
1/3
taken
by
eviction order.
1. The report that you have annexed, page 7, the second line mentions about survey number 1/20. The last paragraph mentions about survey number 1/3/1.
Yes,
What is it?
that's my property, Lord. So they want to evict me from my landed property.
1/3/1 is recorded in his name. That is, nobody is concerned with that. 1/3/1, that is also not the suit property.
But kindly turns to page
That's what
55
your
of the petition.
one has to look into what exactly is mentioned in the suit and what is the survey number mentioned in the writ application.
Please take down. In the writ petition, the petitioner has prayed for removal of the encroachment existing over survey number 1/20. Stop. The private respondent has filed a suit in connection with survey number 1/3. Stop. Paragraph.
And that 1/3 is recorded in his name. He has filed for his land, not in respect of any other land.
Paragraph 2, ascertain the proper survey number where the encroachment has been made by the private respondent.
But I dispute this.
Alleged encroachment. Alleged encroachment took place. Let a spot inspection be conducted by the Tehsildar or by the area revenue field staff. Who is the authority?
Patwari concern must be subordinate to the Tahsildar
No,
concern.
but Tehsildar.
Well, Tehsil.
Patwari cannot do it. Patwari is not the surveyor.
I have
Surveyor.
the regulation, it's a Patwari who can carry out demand. Tahsildar cannot do it. I can show the law.
Surveyor has to.
It's not me saying law should.
By the
Patwari can do it.
by the
Surveyor.
by the competent authority upon prior notice to the petitioner and the private respondent. Within a fortnight from date and place the inspection report before this court on the adjourned date. Let the matter appear in the list in the next circuit. Till paragraph.
And then again, the matter will linger on. So let us look
Till-
into it and decide who is the
Till
competent authority.
till the report is filed, till the inspection is conducted and till the further order is passed by the court, the interim order
It's operating in
granted
this
by the court shall be strictly followed, and the deputy commissioner shall ensure that the order is not violated by any of the parties to the writ petition. Stop. Show me who is the competent authority. এটা একটা হয় ভেন্ট ওপরে তুলতে হবে আর নয় বন্ধ করতে হবে।
101. 101.
Hundred and one. The Patwari shall prepare such statements, returns or lists dealing with the assessment of compensation.
It's not valid on the first part of it, regulation.
Regulation.
This is regulation.
Regulation. Regulation 101.
All right. 101. Demarcation of boundary. No order has been made. The Tehsildar or any other revenue officer specially empowered.
That's what I was saying.
Competent authority. In place of competent authority, mention the Tehsildar.
Okay. WPR 532 of 534.
Yes.
Property in question,
Yes.
when it was purchased, on compliance of certain formalities, like no use, non-encumbrance valuation certificate, needs to be procured first. That would be part of the conveyance deed. Registration would be done, then the mutation would be effective. From my erstwhile owner, same thing was done. I'll show those documents. It's right from page 17, 18. These two documents.
Where is your opposition? Is on record. Yes.
It's 1 second, it's fine. Page 17 and 18. Thanks.
But why in the to be mentioned
Not time has
heading
lapsed.
it?
Time to
for-
file opposition has lapsed.
No, but then opposition has been filed.
They just given the copy today only. Just today only they've given the copy.
Anyway, if the time has lapsed, then it can be extended.
But now this can be taken up from now for finally in this stuff. I want this no use and non-encumbrance certificate.
11th of November.
Yes. Last listed on 6th. Where is the recording as to when it has been filed? 11th of November, it was affirmed. Filed in the department. Date of receipt. Filing date. Oh, this is the date of affirmation. This is the affirmed.
The day it was affirmed on the.
Same day? Same date is filed? All right. So it's 11th of November. It was filed on the 11th, the order was passed on the 6th and it has been done on the 11th.
I want the
In that case, not in the to be mentioned heading. Let it appear for hearing. List the matter for hearing. And record one line, opposition is already on record. List the matter for hearing. You won't file any reply, Mr. Jayapal?
Let me take to this. If that will be granted, I'll come with the reply.
Tomorrow?
Tomorrow.
Very well.
Just 1 day.
The reply may be filed prior to the next date of hearing.
Okay.
Let it come. Make it day after tomorrow in that case. Day after tomorrow.
Have none. Item number 3, WPF I mentioned this matter, sir, they have not filed the opposition, that's why I have mentioned. Now they have served a copy upon me. Let it be day after tomorrow, if I file, I will file.
Very well. Is the opposition on record?
Yes.
The opposition is already on record. Stop list day after tomorrow. Affidavit in reply may be filed prior to the adjourned date.
Item number 4. Just 62 of content. Certification of due to this ill health is out of respect. And it will take.
Next circuit. Very well.
Appearing from the private.
Record your appearance on the prayer made on behalf of the learned advocate representing the petitioner. List the matter in the next circuit.
Right. Item number 5, WPS 63 of consent.
And for the petition, this is the case relating to grant of scheduled tribe certificate to a child born from a scheduled tribe mother and unreserved person, even I can say, who is not belonging to any kind of reserved category. So whether that child will be granted the scheduled tribe certificate or not, that is the point of view. Now, if I don't think opposition is required to be.
Why opposition? Show me the law. Yes.
The judgments are there. I will produce. I have judgments.
What is your stand?
Court also decided this issue in 2 of my matters.
Because factually there is no dispute. Mother is a reserved category and father is non-reserved category. What will be the caste of the child?
So here the scheduled tribe can, persons, they are following matriarchal societies. So I will prove that. Documents are there.
When
And tribal council has recognized it. Tribal council has given the recognition.
take instruction and come back with a report. Opposition will not be required. Who has come? The mother or the father or the who?
Mother.
Mother. A lady has approached this court for obtaining a caste certificate in favor of her daughter who was born out of the wedlock of the lady with a person from the unreserved category. Stop. Next. The official respondents are directed to file a report before this court. With regard to the before this court, apropos the claim of the petitioners for issuance of caste certificate. Stop. When? Next, this Friday? Very well, list on Friday.
Item number 6, WPS 655 of 2024.
Yes. Since when and why is it not being disposed? Where is your
Page 26. The revenue is also initiated by the Tesla concern, but it's still not possibly made case for. My trial also to that effect, the revenue case, it has been initiated by Tesla concern.
where is the case number?
Page 16 of repetition, Your Lordship, where we have given the case number, Your Lordship.
Any response from your side? Official respondents? Yes.
It's not disputed, Your Lordship.
Then
See them in the month.
please come. The petitioner's revenue case being TFGRC number 459 of 2024 is pending disposal at the end of the Tehsildar. So, a notice of mutation to interested persons was issued in August 2024, but the case is yet to be disposed of. Is the date August?
As per
12th of
the-
August?
As per the handwriting. Your Lordship,
It's handwritten, you cannot read it
Yes, Your
properly. Is it 08?
It could
or
be Your Lordship, 05, yeah, so 12th of May, Your Lordship.
May?
No. Yeah, August, Your Lordship, August.
August? Very well.
August.
The instant writ petition is disposed of by directing the Tehsildar to hear the interested parties and dispose of the mutation case at the earliest, but positively within a period of. Is there any statutory time limit?
No, Your Lordship.
No?
Actually, this honorable court pleased to give 2 months time, Your Lordship.
8 weeks from the date of communication of this order. Writ petition disposed.
Lordship, obliged.
Item number 7, WPS 194. The respondent.
Lordship, earlier occasion I moved this writ petition. My review application was pending before 2 authorities. Your Lordship directed the Deputy Commissioner and SDO to dispose of the same. But in violation of that order, he passed some other order, asking the parties, you come to a settlement. And other authority did not heard at all. When I issued contempt notice, he passed mechanically order copying the order of the superior authority. So I challenge both the orders.
This writ application is not maintainable as there is an alternative remedy right before the chief commissioner.
What his court directed you do,
One
he
minute.
said.
Impugned order, where do I get that?
That is page 52. The last portion is page 54. My representation was to review the order. After 10 years, Deputy Commissioner woke up and his stay order passed by the Tehsildar he recalled that order without any authority.
Is the order of the deputy commissioner appealable?
Yes,
This
sir.
order is appealable, but this order is
Yes.
not in accordance with order passed by this court, and my representation at all has not been disposed of.
It says that your demand justice notice, fourth
Disposed.
of 19th of April 23 and the representation
Kindly see
18th
my
of
prayer,
September
what was in
20.
my prayer in the application to the deputy commissioner. My representation,
Page.
just. And my demand justice notice, page 43, Lord.
See, this court passed order directing disposal of your representation after hearing all the parties.
Yes.
The court did not mention as to how it is to be considered or these are the
My
modalities to
application
be
was a
followed.
review application. He has to decide my review is maintainable. He has to decide that review is to be done or not. But in third order has been passed by. So my prayer is let this order be set aside, remand back to the authorities to decide afresh on the prayer made by me.
No, no, he has
Presentation
to
is
file,
page 45. Kindly see the page 45.
it is an appealable order, my lord. They are agreed, they
You
can
can
appeal.
take all points in appeal.
On what ground I will take your lordship? Because
The whatever ground you are taking over here, you can take it in appeal.
this is order completely without hearing me. Second order by the second authority. Kindly see.
Deputy commissioner did not hear you.
Deputy Commissioner did not give proper opportunity for hearing. That is also one of my ground in the appeal application. Denial of natural justice. Other authority completely in one day issued notice, call me on that day, and on that day itself when contempt notice was issued, pass order.
No, both parties were present.
Parties
No,
were
no,
present.
No, kindly come to page 60.
During the hearing, both parties
60.
agreed to get
It's the
the.
key submission of the petitioner recorded.
Page 60,
It's
you
a
know.
detailed order.
Page 60. On that day, first notice was issued to appear. I was not heard anything.
Please come.
My prayer is to remand back the matter to both the authorities.
The order passed by the Deputy Commissioner South Andaman District on 12th September 2024 is impugned in the instant writ petition. Stop.
Two orders are impugned, your lordship. Two orders are impugned.
Page 52, you show
Page 52 and 58, 60, 58. Two orders,
Pass the
Right.
SDO.
SDO. He was not doing anything when contempt notice issued, one day notice issued, called me without hearing, we passed the impugned order. I enclose the notice also, next page,
Both the parties were heard.
not heard by him. And order passed by the Tehsildar is appealable order to the SDO, but Deputy Commissioner taken himself and passed the order, which was under review before him. Even copy paste order, kindly see the dates in the
page
page.
54. I can see
Yes,
from the bottom fourth paragraph,
Yes.
in view of the facts and circumstances, parties are advised
yes.
to file application for subdivision of their land along with the requisite documents.
He was asked to consider my representation. He is advising to go to partition proceeding.
And you admitted that.
No, I filed an objection against this. No admission was there. Before, when I received the copy of the order, I filed an
Request for
objection before
review.
the.
Request for review before the deputy commissioner.
Yes, your lord.
Has any steps been taken for
No,
review?
No steps has been taken. This order has been passed.
This order has been passed by the SDO.
SDO's next page, you have two applications filed by two authorities. Page 45 and
58.
46. 45 and 46. They have to decide my review, not to ask me to go for partition, and admission is not there. I objected this year. Lordship, kindly page 55. When I received the order copy from the Deputy Commissioner, I filed objection that it is incorrect recording in the order. Page 56 last.
It is requested to expand the para 2 of page 3 of the order. Also recall the order dated 13 and consider the representation dated such as. I objected this admission. I never made any admission.
The court directed both the authorities to consider.
Yes, sir.
One is the deputy commissioner and the other is the SDO.
SDO. Page 45 and 46, my applications are directed to be considered along with demand justice notice. He passed.
What was your prayer before the deputy commissioner?
Page 45 kindly. It is therefore prayer that order dated 3/5/19 in file number such and such, as the same is without jurisdiction and honest in eye of law, required to be recalled as per the order of the deputy commissioner, was appealable order under regulation 28, that too within prescribed period of limitation. After 9-10 years, he recalled the order passed by the Tahsildar. Without having, even now, it is not the appellate authority. SDO is the appellate authority of Tahsildars. So that's why review application was filed this, recalling and review.
The problem that you are creating is before two authorities.
Yes.
You've got prayers and both you have tagged in one writ petition.
But earlier on.
Right. Earlier also there was a direction for two authorities
Two
to
authorities.
consider.
Yes.
Yes.
Your Lord.
They are passing diverse orders.
Yes.
Now, the SDO's order will be appealable before the deputy commissioner.
Deputy commissioner.
And the deputy commissioner's order will be appealable before the
Lieutenant Governor.
Left
LG. Right?
Yes.
So, tell me one thing, whether your request for review,
Review, this is my request for
this
review,
is
page 45.
pending.
This is pending.
pending.
This has not been disposed of. Other
This
things
has
have
not
been
been
done.
disposed of. And on the contrary, the SDO has passed a different order in response to your application before
For
the
review.
SDO.
Yes, Your Lord. And
So SDO's order, you can prefer appeal before the deputy
SDO order
commissioner.
is, SDO order is, he's saying the deputy commissioner pass order, you comply with that order. Kindly come to the SDO's order, whether he applied his mind. Page 59.
Yes.
In view of the above circumstances, I being the respondent to have disposed of demand justice notice representation with the direction to
Well,
comply with the
application
order of
for-
the deputy commissioner.
For
He is not passing any order on my application. And even kindly see the date, 4/19/23 in the order of the SDO and 4/19 in the order of the deputy commissioner, copy paste order of the one authority to another authority. Same date, even no change at all.
No, justice demand notice is same.
I am referring the order of the SDO and deputy commissioner.
Yes, because that is the demand justice notice.
Yes.
That is the date of your,
1923, I am showing the copy paste by them not applying mildly, kindly
if your date is
4/19/23.
such, they will change the date.
No, no question. My review application, both the
Cannot be
authorities
done.
is to be directed to decide the review application filed before them. And these orders cannot stand with
What
them.
is your prayer before the deputy commissioner?
Page 45.
What do you want him to do?
I want to recall the order which was passed by the deputy commissioner.
What is your prayer, you tell me, apart from recalling?
Yes,
What is the relief that you are seeking?
because he is not the authority to vacate the order passed by the Tahsildar. Order passed by the Tahsildar is appealable order. Other side ought to have approached to the SDO for challenging that order. And after 9 years, the deputy commissioner recalled that order by the, which order I sought to be recalled.
What is the ultimate relief that you are claiming? You want the land to be recorded your name, you want something else?
No,
What do you want?
My question is illegal diversion was done by the authorities.
What
On the
diversion?
false affidavit, house site was converted without subdivision and partition of the land, without specifying the portion. It cannot be done until unless it is subdivided.
Diversion from what?
From
Agriculture
agriculture
to
to house site.
non-agriculture,
Yes.
house site,
Yes.
non-agriculture.
And a false affidavit is submitted by the respondent, private respondent.
Where is that order by which the diversion has been allowed?
That is the start from page 31. Even no notice was given to me by SBU. I am one of the joint recorded owner of the book. The application starts from page 29.
And 1st of July 2019 is the order
Order.
by which the conversion took place.
Conversion put here. This is the handwritten order.
And
In the light of the order of the deputy commissioner, he did all these things earlier also. Page 32 is the last order, 5819. Present such and such submission upon the direction
8th
of the
August
deputy commissioner.
2019 SDO's order.
SDO's order, page 32. He is saying as per the direction of the deputy commissioner, filed a petition for diversion case. And he is not doing himself. As per direction of the deputy commissioner, as per impugned order, which I want to recall.
Page 35 and 36,
Yes,
the SDO's order,
yes, yes,
RC.
yes, Lord. That is the, when.
This is the principal order out of which you are aggrieved.
Yes, recall was filed before the. SDO.
This is the order you want to be
Yes.
recalled.
Yes. But SDO saying you comply with the order of the deputy commissioner.
This is in concern with the private respondent, the petitioner
Yes, the private respondent, that's why.
conversion was made upon the land of the private respondent.
It was joint
And
property.
upon
How
payment
it
of
can be
fine.
done without subdivision.
Please come. Let me hear you. Who are you?
I'm representing my mother in this case.
All right.
Ma'am, the private respondent has paid the penalty for illegal diversion, madam.
Private respondent has?
Paid the penalty for illegal diversion. Page number 34 in the book.
Yes. So that means you admit that the diversion was made illegally?
No, ma'am, we are staying in the property since 35 years.
Yes.
And we had already had a house in that land. Ma'am. Since
But the
35
land was recorded as an agricultural piece of land which you are used for non-agricultural purpose. Isn't it? And you admit that and you paid the penalty. And you seek regularization of this.
Madam, we have the diversion, madam. Like we
Yes,
need the
yes.
penalty for 300 square meters for the outside purpose only.
And in whose name is it recorded?
My mother,
Joint name it is. not
my
single.
mother name,
Solely in your mother's name.
yes,
Where do I get that?
page number 35.
35, yeah.
Where is the name of your mother?
This order shall dispose of the request for diversion. from
Page
the-
20 is the record of
One
right.
minute, 1 minute. Usha Kiran,
Sure,
your mother.
yes,
That is the request for diversion, but in whose name is the property recorded?
Page 20 is the joint property.
If it is a joint property, then how can it be considered or diverted only by consideration of one of the parties? Usha Kiran and Madhu Prakash,
Yes, Madhu Prakash is the applicant. Jointly recorded.
the sister and brother.
Yes.
No partition made.
No partition made. Deputy Commissioner asking to go for partition.
What do you want? Your sister to be
No,
thrown
I
out
don't
from
want.
there?
Illegal order should not remain in the file. That is my
Tell me
point.
what you want. Any type of settlement? You want your sister to stay there or not?
No, but she submitted a false affidavit. Now it's submitted 30 years we are residing, house is not there. Affidavit may be seen, your lordship.
What are you doing with that land?
This is agricultural land.
How is she staying there with a house constructed?
House constructed by the father, she is residing there. She
Yes.
made incorrect statement to the authority and diverted more 300 square meter of land, joint property. That is false affidavit.
my lordship, finally come to page number 27. We have applied for the diversion of land in the year 2008 and the same was rejected because of the not giving.
Objection
Yes.
raised by them.
Yes. And page number 25, madam. The honorable deputy commissioner has there in paragraph 3, madam. and wherein this clearly establishes that the sole purpose of the respondent is to trouble the petitioner and stop her to utilize the land for basic human requirement of the house. Therefore, in view of the above, I am of the opinion that as the requirement of accommodation is one of the basic human requirements, the stay order of the Tehsildar Sarganj dated 10 September 2009 is hereby vacated. The petitioner is directed to apply for diversion of land.
After
Into
10 years,
outside-
he is vacating the
outside
order.
Subdivisional officer, South Andaman within 1 week, and subdivisional officer shall, after receive such application, shall dispose it of within 2 weeks from date of the application.
But then it is not for the Tehsildar or these official respondents to look into the private disputes in between the parties.
Diversion, I am on diversion, and I am on, kindly come to page 24, Your Lordship. 2009 Tehsildar pass and stay order, and 2019, after 10 years, Deputy Commissioner vacating that order. How that is possible?
My right to life violation.
Even the Deputy Commissioner is the second appellate authority. SDO is the first appellate authority of this order. After 10 years, he is doing all these things, directing the SDO, directing the petitioner, and without hearing me, he passed these orders. So that's why I filed for recall these orders and hear me, and then pass order, whatever he wants,
No, petitioner was heard.
when he was heard. Place the record,
Please come. The
2019 never heard.
petitioner is aggrieved by the order of the subdivisional officer. Allowing the prayer of the private respondent for diversion of a plot of land from agricultural purpose to non-agricultural purpose. Stop. Next. According to the petitioner, the said order was passed without affording the petitioner a reasonable opportunity of hearing. Stop. The land in question is recorded in the names of the in the joint name of the petitioner and the private respondent, who are siblings. Stop paragraph. The petitioner preferred an appeal before the deputy commissioner, which was also disposed of, not also, which was disposed of on 12th September 2024. Stop. The deputy commissioner advised the parties to file application for subdivision of their land along with requisite documents. Stop. Next. A prayer for review of the order of the deputy commissioner is allegedly pending before the said authority. Stop. The subdivisional officer, paragraph, the subdivisional officer has also passed an order on 11th October 2024 directing the petitioner to comply the direction passed by the deputy commissioner. Paragraph, the petitioner is aggrieved by the same. Stop. It has been submitted that the subdivisional officer acted mechanically without considering the prayer of the petitioner. Stop. The deputy commissioner, without application of mind, advised the parties to pray for, not pray, to apply for subdivision of the land. So, it has been submitted paragraph, it has been submitted that the deputy commissioner does not have any advisory power, and accordingly, the advice given by the deputy commissioner is bad in law. Stop paragraph. The private respondent is represented by her daughter. Stop. It has been submitted that the private respondent is residing at the said place by constructing house for nearly 30 years, 35 years. Stop. As there is scarcity in the place to stay, accordingly, a request was made before the authority for diversion of the classification of the land, which stood allowed in August 2019, and the private respondent also paid the penalty that was directed to be paid. Stop paragraph. It has been submitted that the order for diversion has been passed, keeping in mind the right to live with dignity at the subject place where the private respondent is residing for nearly 3.5 decades. Stop paragraph. Upon hearing the parties and on perusal of the materials on record, it appears that an issue has been raised with regard to the quantum of land occupied by the parties. So, the record of rights evidences that the land is recorded in favor of, is jointly recorded in favor of the petitioner and the private respondent. Stop. The private respondent is residing at the said place, for a considerable period of time. The private respondent is residing in the structure constructed at the said place for a considerable period of time. Stop. Next. The portion of the land where the construction has been made and is in existence for such a long period of time cannot be taken to be as an agricultural piece of land. So, however, the quantum of land where the construction has been made is disputed. Stop. It will not be proper for the writ court to enter into any disputed question of fact. Stop. The period for which the private respondent is occupying the land for residing over there is also disputed. Stop. Next. In view of the above, the court is not inclined to exercise jurisdiction in the matter. Stop. It will be open for the petitioner to approach the competent forum for remedy. The writ petition stands dismissed.
Much obliged.
Matter number 8, WPS 667 of 2024.
But I am for the petitioner.
I'm for the respondent.
The impugned order is at page 64.
Yes.
Based on the direction passed by this honorable court, it was decided. File is not traceable, therefore premium cannot be accepted. This is the impugned order. Kindly come to page 45 first.
45.
Which is 64 is the impugned order,
Yes.
45 is the license
Alright.
granted by the authority on 5/10/1989.
Yes.
Can you see the date, madam? Bottom,
5th October 1989 in favor of Anand Prakash Topo.
the petitioner hearing.
All right.
I approached for making payment of premium for the purpose of obtaining record intent map. They are sitting tight over the matter.
When did you approach?
I approached the authorities, they are sitting over the matter.
Say when?
I approached this honorable court. This honorable court directed the deputy commissioner to decide. This decision is at page 64.
Yes, this I follow. So 89, you rely upon a document, the license is of 89,
No, no.
and you go there for getting the records corrected in
2016.
2016.
Yes. Kindly see page 65, madam. First paragraph, and whereas the Tahsildar settlement 2 where note dated so and so reveals that the requisite file documents are not traceable even after repeated attempts. Then genuineness of the copy of the license produced by the petitioner cannot be ascertained. In similar case, my lord, everybody was given. I will show that also. It is appearing at page.
the original license, Milord.
He couldn't.
You have to verify it.
Because so,
Please let me
there
submit.
is your
My lord,
original license.
let me submit.
Yes, yes, I'll
There's
hear you.
a
Please wait.
copy of the license.
All right, I'll hear.
If your lordship can see.
Please
I'll
wait.
hear you, I'll hear you. Yes.
Page 67.
Yes.
Page 67, 69, 72, and 71. 4 persons approached this honorable court. Based on this, premium was accepted. Similar matter. I can show from the documents obtained under the RT Act. The operative portion is page 82.
No, but in the other cases, whether originals were there or not, you do not
There is no
know.
whisper in the order. Order passed by the deputy commissioner. No, I'm coming. There is no whisper in the order. Now, my lord, I obtained under the RT Act, page 82 may be seen. This is some other person. Just example I am showing. Paragraph 3 may be seen.
Yes.
After issuance of license, the concerned revenue case files sent to concerned Tahsildar for necessary entry in the records. The petitioner's case was also sent to Tahsildar Port Blair after necessary entry. The above said case file of the Bursabad village not returned to this office. As such, the case file of the village of the Tahsil returned this office. And Tahsildar Port Blair reported that the above file not traceable. Further verified with duplicate copy of the license, Puspa village reveals that Srimati Anita Puspa Tirki, duplicate copy of the license available in this office, copy of the license flag A. Hence approved, he may issue a notice to the petitioner of concern for conduct of field inspection for compliance of the underlying court's order. Based on this Puspa Tirki was given.
But then duplicate copy of the license was available in the office.
Yes, but it is their duty to trace the file. File is not getting, for that reason I cannot be made liable.
Show the original. Whoa, who is going to to verify the genuineness of page 45?
The record reveals them, my lord. It is a genuine document.
Where from the record will reveal?
Page 45, it says.
Page 45.
Yes.
Who is going to check the genuinity?
If your lordship sees page 66.
I obtained the copy under the RTI Act also, page 66.
Page 66. my lord,
Please
can you
wait,
please-
let me finish.
Whether your lordship can read the
Yes.
name of
Yes,
the licensee.
Anand Prakash Topo,
Overwritten.
Anand Prakash Topo,
This page 66 you obtained under the
RTI.
RTI.
bottom seal is there.
Show the original ones.
RTI original, this is the original one.
It's also illegible. This is also illegible.
The extract
Who
from the
is
office
the
copy.
SPIO? Who provided this information?
Public information officer of the office of the Deputy Commissioner.
Please check up whether you get this in your records. Page 66. Please come. The petitioner prays for correction of the record of rights.
No, not correction error.
It's called
Acceptance of premium. pursuance of
petitioner
arrow.
prays for acceptance of premium for issuance of the record of rights, relying on a license which was allegedly issued to him on 5th of October 1989 by the Assistant Deputy Commissioner, Port Blair. So, paragraph, the prayer of the petitioner stood refused.
It is there in the report itself, when in the proceeding, the Deputy Commissioner himself written. Proceedings. Page 59 now.
Yes.
The last paragraph. Now he has come with a single.
1 minute, please wait. Could not be exceeded as the genuineness of the copy of the license produced by the petitioner could not be ascertained as the relevant files/documents are not traceable. Stop paragraph. Learned advocate for the petitioner submits that copy of the license was supplied to the petitioner under the Right to Information Act, and the same is annexed at page 66 of the writ petition. Paragraph. Learned advocate representing the official respondents submits that in the absence of the original license, it will not be possible for the authority to accept the premium. Stop. The genuineness of the license relied upon by the petitioner is required to be ascertained. Paragraph. The learned advocate representing the respondent authority is directed to revert with regard to the document at page 66 of the writ petition. Stop. Specific instruction is to obtained as to whether page 66 specific instruction has to be obtained with regard to availability of page 66 in the official records.
Yeah, duplicate is available there. It's there in the proceedings.
Proceedings of some other person.
No,
It is not-
no.
List the matter on Friday.
Proceeding,
13th.
well, initiated page 58 may be seen at a minute.
Let her come back with instruction with regard to
PC
66.
himself reported that copy is available in the.
Very well. If it is available, you'll get it. This Friday, I'm keeping it.
Well.
Item number 9, WPS 673 of 2024.
Under the petitioner. Here the case is relating to
delayed promotion. Means DPC delayed convening of DPC by the authorities. What happened? This petitioner, she was.
What is your ultimate relief?
I am praying, Your Lordship, refixation of my pension.
Pension.
Yes, because I have been what they have done, they convened the DPC, they made me to undergo training, and after that they have delayed. And by that time I got superannuated. I know my limitation. I want that the scale of pay refixation, that the pension has to be refixed, and I have to be given the scale of pay of promotional
And
post.
after you are making this prayer, after you have superannuated from service,
Your Lordship,
is it maintainable?
maintainable, Your Lordship, I have decision. A very recent
Very
decision is there.
decision.
Yes, recent decision is there relating to exactly the same issue.
Sure.
Your Lordship, this is. Hard copy. Your Lordship, I don't have the hard copy. May I cite the decision, Your Lordship? Or else it can be taken up tomorrow, Your Lordship, I'll place it.
List the
This,
matter
this is
tomorrow.
otherwise an admission matter. If your lordship is inclined tomorrow, then we'll seek time for opposition. This first time it is appearing.
I understand, but then what will
Then
you,
permit me to file opposition.
what will you say in your opposition? If you insist, I can give
No,
direct.
my lord, we'll have to file opposition.
Sure. Please come. The
My lord
matter
can
is-
keep the point of maintainability open.
The matter is required to
Very
be
fine.
decided upon exchange of affidavits. The petitioner is a retired employee. So he seeks refixation of his pay on account of delayed promotion. Was he at all promoted? No.
She was promoted once.
No, but
To
then the
the
refixation you are seeking is in respect of a promotion which was not allowed. at
Not
all.
allowed. I will satisfy Your Lordship to that particular point. Decision is there. I won't
Did
be
they
able to
say?
get the salary.
Uh, a refixation of her pay. Refixation of her pay. Stop it over there. Stop. The respondents seek time to file opposition in the matter. Stop. Let affidavit in opposition be filed within a period of 4 weeks. Reply, if any, within a fortnight thereafter. Liberty to mention the matter for hearing before the available circuit.
Your Lordship, obliged.
Item number 10, WPS 679 of 2024.
My lord, I am appearing for the petitioner, my lord. Here, my lord, the petitioner, he is a joint recorded tenant. He came to know that the land has been acquired as per the land acquisition proceeding. My lord, he has given the representation before the authority, that is the collector land acquisition, by saying that I have not given with the compensation. My lord, the land acquisition, the officer, they have given the letter by saying that your land has not been acquired on the basis of the report filed by the Tehsildar. My lord, I'll show to that.
So what is your relief now?
My lord, my lord, that is there. My lord, in the report, there is an award. The report has been annexed in the award. My name kindly be seen, my lord, it's at page 28. Page 21 is the award. I'll show the page 26 kindly be come, my lord. Resettle and Development Plan Rules 2018 and furnished report including the details of affected tenants along with their respective individual affected share. The Tehsildar Port Blair furnished the updated status report which is reproduced as below. My name comes under at page 28, my lord. Not within the affected area. This has been given by the Tehsildar, my lord. Now I have given a representation before the Tehsildar to demarcate my land. What they have done, my lord? This is the representation at page 43. They have given the notice. I've submitted the demarcation fees also, my lord. It's at page 44. 45 is the notice, my lord, wherein the date has been fixed for demarcation. That day demarcation was not done, my lord. Thereafter, my lord, next page, kindly be seen, my lord, 46. This is again a notice by saying that, second paragraph kindly be seen, my lord. Notice were issued to all stakeholders for demarcation of subject land on so and so date by the revenue surveyor and submitted a report that the map of the subject land is not marked in the FMB. And now therefore you are hereby directed to appear before this court on 31/7/2024 along with sketch map and documents related without fail. Their own document is there, my land has not been acquired. So I want my land should be demarcated.
What is this FMB?
A field measurement book.
All right.
All these documents is with the Tahsildar. The sketch map, the FMB.
First of July, did you appear or not?
My lord, I appeared, my lord.
You appeared.
Appeared.
Where is
But-
the fate of your
My
application?
lord, thereafter no notice was given, no order was passed, my lord. Demarcation was not conducted, my lord. My specific prayer, my specific representation was to demarcate my land. All these documents, what they are asking, my lord, it is with the authority. They themselves have stated that my land has not acquired by the, under the acquisition proceeding. That report they have submitted before the.
Let me hear.
Instruction. Because this is the
Please
first time not any.
Very well. Please come. Can you come back on Friday?
Well, my lord, let there be direction for filing affidavits, my lord.
For this
Because,
demarcation, my lord.
Why they have asked for the sketch map and.
Yes.
Because there's a specific note, my lord, on the last page that notices were issued because the petitioner is not a single person. If others are there, 17 more persons were there. They are the joint recorded tenants. So whether everyone was present or not, and for this writ petitioner, my lord, they're asking for a map which is not shown in their field measurement book. So, my lord, this requires to.
But their own report says, my lord, at page 28, my land has not been required.
Demarcation of his land.
That is there, my lord. My land is still,
Because they have initiated the demarcation process, not page 45. They have sent, issued notices. Thereafter, they come to know that the map is not showing in the field measurement book.
then how they have filed this
What does
report,
this
my lord?
mean that the
In the
Uh,
On
demarcation
what basis
process
they have filed this
required
report before the collector?
For measuring and all. Because
There must be
17
record.
joint
Yes, my
recorded
lord.
tenants, my lord.
Otherwise, how they have come to the conclusion before the
there must be
collector?
some record
Yes, my lord.
from where it can where it
That is
was
from the
intimate.
field FMB, field measurement book, my lord.
Yes.
In that only they can demarcate the land because this is not a single person, all 17 stakeholders
And
are
the
there.
field measurement book is supposed to be with you.
Yes, yes.
Then why will the petitioner not get the relief if the field measurement
So
book
they
is not
are
there?
asked to bring their map along with them.
Map must be with you.
Yeah, ma'am.
It's not necessarily the map will be there with the parties.
My-
Map, you are the official respondent.
my-
You must be having map. The FMB, the map and everything should be with you. Isn't it?
My lord, let this matter be fixed on Friday, my lord. I'll take instruction and come.
Yes, I was thinking of disposing, but since
Ma'am.
you want some instruction, then
No, my lord, let this matter be fixed on Friday.
very well. Seeks demarcation of his plot of land. Stop. The process of demarcation was initiated by the revenue inspectors. And a date was fixed for demarcation. Stop paragraph. Stop thereafter. A direction has been passed for production of the sketch map and documents relating to the subject land. Stop paragraph. From the document annexed at page 28 of the writ petition, it appears that the land of the petitioner was not affected by acquisition. Stop. Next. The official respondents must be having documents in support of the land which the petitioner seeks demarcation. Stop. Let a report be placed before this court on 13th. List on 13th.
Obliged, my lord.
Number 11, WPS 680 of 124.
Lord, here I'm appearing for the petitioner, my lord. Lord, service is affected, whether
Not affected.
affected, I filed the affidavit of service.
So not a middle agreement. So I have not received a copy of the written application.
I'll keep it on Friday or
My
Thursday.
lord, I'll give the spare copy, my lord.
Friday. I
Friday.
take instruction.
Very good. List the matter on 13th. Learned advocate representing the official respondents shall come ready with necessary instruction.
Obliged.
Number 12, WPS 320 of 124.
Soon I am appearing to the respondent authorities. We have filed our opposition in the registry, my lord. I am serving the copy to both the writ application as well as the supplementary affidavit.
Let me come back day after tomorrow, your lordship. I'll just go through the opposition. If it is required, we'll file reply. Otherwise, we'll make our submission. Because we have already taken steps.
No, only for partially.
Only
Then
for-
partially, we have taken steps, he's saying.
Only up to salary who is receiving 15,000. For those only they have paid the EPF amount, not the
That's it.
others. No.
No,
They have to pay for all the employees.
no. That is not the.
Otherwise,
The affidavit in opposition is already on record. Stuff. A copy of the same has been served upon the learned advocate for the petitioner in court today. Stuff. List day after tomorrow.
obliged, my lord.
WPS 356 of 124.
But these three matters, can it be taken up tomorrow? I'm just tired.
Tomorrow. It's already 3:20.
Well, day after tomorrow.
3 matters.
Day after tomorrow, by consent of the parties.
In
List the
item
matter
number
11.
15, I am a respondent.
Record everybody's appearance.
Number 16.
Item 16, my
15
lord.
Lordship, I am appearing for the petitioner, Lordship.
My lord had adjourned the matter, directing us to inform the court as to what happened. This is that, my lord, this is that matter which was moved initially before your lordship in the principal bench.
Yes.
Then it was taken up here and the petitioner operates a kiosk in Havelock, Nescafe kiosk. So the committee was scheduled to meet and I had informed the court that we'll get back after the deliberations of the committee. So my lord, this is the report of the committee. I'm just handing it over. And my lord will see 3 months extension has 3 months extension has been granted. Kindly see the last para. Accordingly, Space Allotment Committee recommended for further extension or temporary allocation for 3 months. All other terms and conditions shall remain unchanged. So today there is this writ has become infructuous. Of course, if some fresh cause of action arises, they can always challenge it.
Forward a copy to your learned friend. Given to his client.
Lordship, no copy has been served, so let them instruct them. I'm sending my client to their office to get that copy over there.
Recording that this
Yes,
has
yes.
been placed in court.
If they have some advocate on record, I can serve in court also. If somebody is there in here.
Is there anybody on your behalf in the court complex?
No, not there, Lordship. But I'm directing my client to meet by today to their office, Lordship.
Your phone number recorded in the file so that a soft copy can be forwarded to you
Yes,
over
yes,
the
if you can,
phone.
that
Yeah,
can-
my phone number and email ID is there, Lordship.
I don't have it, my lord, if you can give it.
In my copy, the back sheet, there is the phone number and the email ID.
It in the chat box.
Okay, Lordship, I'm giving this.
A report signed by the manager within bracket cargo operation. Port Management Board, Andaman and Nicobar Administration, signed on 9th December 2024, has been placed before this court by the senior counsel representing the said authority.
My lord, just with your lordship, I'm very sorry, Mr. Mishra is here. He's the brother of the petitioner. So I'm giving him a copy now and here.
I will
He'll
provide.
communicate. He'll represent.
Brother of the petitioner means brother of Shiva Mary.
Yes, yes.
Is Mr. Das aware of
No,
the-
I'm not aware, but if I can contact my client to collect from him.
I will take a photograph, I will send her.
No, keep the hard copy. Yes, yes.
something should reach him, nothing more.
I will.
The report mentions that the Space Allotment Committee recommended further extension of temporary allocation of open space measuring an area of 150 square feet within bracket 13.935 square meter at Swaraj Deep Jetty for Nescafe kiosk to Messrs. SR Trading Company, Shri Vijayapuram for 3 months with effect from 1st December 2024 to 28th February 2025. Stop all other terms and conditions stipulated in the allocation letter number is recorded, please take down, shall remain unchanged and are to be followed strictly. Stop paragraph. In view of the report placed before the court today, the cause of action for filing the instant writ petition does not survive any further. Stop. The writ petition accordingly stands disposed of. Stop. The party shall take steps in accordance with the report filed in court today. Stop. Let a copy of the report be made over to the petitioner or her counsel by the day. Yes.
Grateful, Lordship.
Item number 17, WPS 609 of 2024. Lordship, though there is a direction upon the petitioner to serve me a copy, but I have not received the copy. From item number 17 to 21, Mr. Prakash is appearing for the writ petition. I have the instruction to not today.
Why has copy not been served? You did. And then copy as in that case, it will go to the next circuit if it is not done. I'll place it day after tomorrow.
Yeah.
In the meantime, service of the writ petition should be there. And accommodation has been sought for on behalf of the learned advocate representing the petitioner. Stop. List on 11th. Stop. Copy of the writ petition shall positively be served on the learned advocate representing the respondent authority in the course of the day. Till 21, same order.
Item number 22, WPS 639 of 2024. I am appearing for the respondent. Same line order may be passed.
Copy not,
To
sir?
dispose, no, I have received the copy to dispose of the representation by the respondent authority within a time frame.
Where is the application? The page 11, application filed by the petitioner for availing new service connection for supply of energy is pending consideration at the end of the electricity department. Stop paragraph. Without entering into the merit of the said application, the instant writ petition is disposed of by directing the respondent authority to consider and dispose of the petitioner's application in accordance with law at the earliest, but positively within a period of 30 days or
6 weeks.
6 weeks from the date of communication of this order. Stop. The formalities required to be complied by the petitioner for obtaining electricity connection shall be made known to him. Maybe her. Jaya Lakshmi is there.
Item 23. Same 23, 24, 25. Same order.
22, 23 and 24.
25 and 25.
25 also?
That's it.
Same? Very well seen.
26 also.
Let the petitioner come. 25 petitioner there. Very well. You are 26. Same order for consideration and dispose. Very well, same order. Have you checked up whether the applications are there or not?
Good. Item number 27. WPS 663 of 24. 27 and 28, Lordship, they have already enjoying one connection. In the
Intimate.
same.
Intimate the petitioner that you are enjoying connection. We will not give new connection.
Lordship.
Where is
That
the
is the order.
petitioner?
I could not find him.
None represents the petitioner. Urgent till day after tomorrow.
Lordship.
Bring a copy of the order that you are relying upon.
Lordship. Your Lordship has passed the order.
Yes.
I will bring the copy.
Very well. 27, 28 both. Same.
Item 29. WPS 670 of 24. Lordship, I am for the petition. Same order, Lordship. Dispose of within 6 weeks.
Disposal? Very well. Same order disposed. 29.
Obliged. Item 31. CPN 53 of 24.
Yes.
Application, my lord, the honorable judge passed the order is there.
Is there?
So that.
The file may be placed. Who is the honorable judge?
Directed to place the file.
Who is the honorable judge?
Check one credit.
All right. The contempt arises out of an order passed by His Lordship, Dr. Ajay Kumar Mukherjee. Stuff. The registry is directed to place the file before the honorable judge. Right? Doctor नहीं लिखा? अच्छा তাহলে তাই ঠিক আছে লিস্টে কিন্তু ডক্টর লেখা আছে ঠিক আছে না অর্ডারে লেখা না থাকলে দেওয়ার দরকার নেই
Item number 32. WPS 137 of 2020.
Lordship, I am for the petitioner. Lordship, talks are going on between the municipal and the petitioner, and there are every chances that this matter will be settled. Lordship, I pray this matter will be in the next circuit. Yes. Talks are going on, Lordship, and there are chances that it will get settled.
Learned advocate representing the petitioner submits upon instruction that talks of settlement are going on in between the parties. Stuff. In view of the above, let the matter appear in the next circuit.
Good. Obliged, Lordship.
Item number 33. So 33 WPA 180 of 2022.
Lord, I am appealing for the petition. Lord, day before yesterday, in similar four matters were there, wherein Mr. Satadu has opposed me. My lord has passed an order saying that there are disputed question of facts to the appropriate forum.
The same order can be, give me a copy of that
My
order.
lord, I can give the number to court of
Very well.
similar order. Has it been served? I don't remember. Which department? Who first? Same.
Forest I appear,
Same,
my lord.
same.
Appearance can be
I
recorded.
will give the number.
Yes,
Yes.
then the same order can be
Same
passed.
order.
My appearance may be recorded.
Yes, the
Forest
reference will
department
be
type.
recorded. Very well.